Ayes. Oyez, oyez, oyez. All those who have business before this, the United States District Court for the Northern District of Indiana, are now admonished to draw near and give their attention, for the court is now sitting. Judges Yates, Burnett, Alexander, Moon, Chief Justice Sullivan, Judge Turk, Pero, Gamble, and Farrar are now presiding. Now calling case number 82A04-8876-CV285, White v. Patrick Gibbs and O'Malley's Tavern. Please be seated.
Well, good afternoon, everyone, and I want to give a hearty welcome to the Northern District of Indiana. We're very pleased to have you in the Hoosier State this afternoon, and interested in hearing a little more about this very interesting question of Indiana law. I understand that we have a motion for summary judgment by the defendant, Mr. Gibbs, in front of us. We're going to divide our time 15 minutes to each speaker on each side. Because the court wants to get to the bottom of this matter today, if the red light comes on in the middle of an answer, just go ahead and finish your answer. You don't need the court's permission to do that. And the members of the panel might even have a question or two for you after the red light goes on. That's a matter of us really wanting to get to the bottom of this. I understand that Attorney Walton is the first speaker this afternoon, moving for summary judgment on the behalf of Patrick Gibbs and the O'Malley talent. You're Mr. Walton. You can proceed when you're ready.
Good afternoon. May it please the court. My name is Benjamin Walton, and along with my co-counsel, Mr. Jordan Van Meter, we represent the defendants, Patrick Gibbs and O'Malley's Tavern. I will be addressing here the issue of actual knowledge of visible intoxication as required under the Indiana Dram Shop Act, and my co-counsel will subsequently be addressing the issue of proximate causation as required under the same act. The evidence here is insufficient to support a reasonable inference that John Daniels observed any sufficient visible manifestation of intoxication on the part of Edward Hard. This court should grant the defendant's motion for summary judgment for the following two reasons. First, Hard was not engaging in any type of activities that would have adequately demonstrated any signs of intoxication.
But he was drinking a lot of drinks, wasn't he, over a short period of time?
Yes, Your Honor, he was.
Mr. Walton, did he have to observe the drinking? Or answer that question first.
Yes, Your Honor. The statute requires actual knowledge of visible intoxication. The Seventh Circuit in Culver v. McRoberts held that constructive knowledge is insufficient to satisfy this standard. Therefore, it has to be a subjective standard.
But can't there be an inference?
There can be an inference of subjective actual knowledge, but there cannot be constructive knowledge.
Aren't you legal? Go, excuse me.
Can't actual knowledge be shown by circumstantial evidence?
Yes, Your Honor. Circumstantial evidence, Indiana courts have held, may support an inference of actual knowledge, but circumstantial evidence may not be used to support the idea of constructive knowledge.
Mr. Walton, let me ask you this. How much would a person have to drink to be intoxicated?
Well, Your Honor, the amount of alcohol consumed would differ with each individual person, and there is no bright...
Based on their size and metabolism and things like that?
Yes.
Is there some number of drinks in a certain period of time that you would say that all of us would know that no matter how big the person is and no matter how slow that person's metabolism might be, that person's going to be drunk?
No, Your Honor,
You don't think a bartender, an experienced bartender, would know that I don't care how big the guy is, I don't care how slow his metabolism is, if I serve him 4 to 6 shots and 1 beer in 30 minutes, no matter how big he is, no matter how slow his metabolism is, he's going to be drunk?
Yes, Your Honor. The amount of alcohol consumed may support a reasonable inference of intoxication per se. However, there is no bright-line test to determine visible intoxication based on merely the amount consumed. Different patrons who are engaging in different levels of activity, even though they may be intoxicated, will not necessarily be demonstrating visible acts of intoxication simply because they have consumed a certain amount of alcohol.
But didn't your client hand out a chart to its customers that showed the amount of alcohol consumption per hour and blood alcohol level based upon weight?
Yes, Your Honor. And this,
So there was knowledge. Is that correct?
there was the evidence from the chart is sufficient to establish at least constructive knowledge of the fact of intoxication, but it is insufficient to support actual knowledge of visible intoxication. Visibly intoxicated under the statute requires not simply that a bartender would know that a patron had consumed enough alcohol to be intoxicated, but would rather, the statute requires explicitly that that level of intoxication is manifested in a visible and obvious way to the bartender.
Excuse me. Counselor, what if the statute read the person furnishing the alcoholic beverage knew or should have known that the person was intoxicated? Would that change the meaning of the statute?
Yes, Your Honor, it certainly would, for 2 reasons. First is, if the statute said should have known, then constructive knowledge would be a sufficient standard. However, the Seventh Circuit explicitly noted that the language of the statute as it stands, citing an Indiana Supreme Court case, the Seventh Circuit has explicitly stated that constructive knowledge will not suffice because actual knowledge is required under the statute. The second reason why that would be a different interpretation of the statute is because it would not require visible intoxication, but as you said, only merely knowledge of intoxication.
Mr. Walton, I'm curious why you say the Seventh Circuit citing to an Indiana Supreme Court case. Do you have an Indiana Supreme Court case that says that constructive notice is not enough?
Yes, Your Honor. In the Indiana Supreme Court case from 1988, Garriott Construction Company v. Foster, the court there specifically held that constructive knowledge was insufficient.
And that was the case the Seventh Circuit was relying on?
The Seventh Circuit explicitly cited that case, relying on that to, again, affirm that under this particular provision of the Indiana Dram Shop Act, constructive knowledge will not suffice.
Sounds like you think that the Seventh Circuit's view of Indiana law is more persuasive or controlling than the Indiana Supreme Court's view of Indiana law.
Either way, Your Honor, whether it is the Seventh Circuit or the Indiana Supreme Court, they have both stated the same thing.
Now, what was the common law prior to the adoption of this statute?
The common law prior to the adoption of the statute was involved with, it did permit constructive knowledge for a common law negligence action. Here, however, we do not have a negligence action being maintained by the plaintiff in her complaint. We have merely a statutory action.
You know the canon of statutory construction that says statutes in derogation of the common law shall be strictly construed?
Yes, Your Honor.
Wouldn't it be fair to say that since the common law prior to the adoption of the statute permitted constructive notice, and the statute now doesn't specifically forbid constructive notice, and that if statutes are to be in derogation of the common law to be strictly construed, wouldn't we want to say that the legislature here hasn't abolished constructive notice because they haven't put anything in the statute that specifically does away with it?
Well, Your Honor, if that was the legislature's intention, they certainly have had plenty of time since 1988 when the Supreme Court ruled that constructive knowledge is insufficient under this statute to go back and make explicit the fact that the legislature was not intending for the statute to be construed that strictly.
Is the Ellspermann case still good law? And if it is, I mean, how do you square your position with it?
Yes, Your Honor. The factors that were adduced by the court in Ellspermann as factors that a court may look at in order to evaluate whether the circumstantial evidence would reasonably support an inference of actual knowledge are still good law and have been used by subsequent Indiana courts in analyzing this particular issue of actual knowledge under the Dram Shop Act.
Well, that case is very similar in its facts to your case, isn't it?
There are some facts that are similar, Your Honor. However, there are significant facts that are certainly distinguishable, such as the fact that in Ellspermann, there was the tavern patron there was engaging in open and obvious behavior that indicated his level of intoxication prior to the point at which he had been served his last drink, and he was doing this in the presence of the bartender. He had put his arm around another man, telling him that he loved him. This was reportedly typical of that particular patron when he was intoxicated. He did this in the presence of the bartender, and at that point the court held that based upon that evidence as
So
well
did
as
the bartender say that he observed that?
No, Your Honor. The evidence was simply that that patron was exhibiting that particular signs of intoxication while he was in the bar. Here, however, the distinction is that we have explicit evidence.
Well, this man tripped over the cue stick, and the bartender was present.
Well, no, Your Honor. Mrs. White explicitly testifies that John Daniels had gone out of the room prior to the point at which Hard tried to stand up from his bar stool, tripped over the pool stick, and fell. By the time John Daniels came back into the bar, Hard had already gotten himself back up, reseated himself on his bar stool. Thus, John Daniels was not present to observe this particular incident, which means that this incident cannot be used to support an inference that John Daniels subjectively knew of this visible intoxication.
Well, the bartender did see him fall as he tried to engage in the fight at the front door as he was leaving the establishment, correct?
Yes, Your Honor, and that incident occurred after John Daniels had already served Hard his last drink.
Well, couldn't the court assume that he saw other indicia of intoxication prior to that encounter?
In the absence of any other evidence of what Hard was doing prior to that point, yes, Your Honor, the courts have held that may reasonably be inferred.
Well, how is the facts in this case any different from the facts in the Jackson case?
The facts in the Jackson case indicate that the patron was simply drinking and playing pool. The evidence in that case was open to an inference that the patron would have been doing things to visibly manifest his intoxication. Here, however, we have Hard simply sitting on a bar stool consuming shots of whiskey. We have the plaintiff herself testifying that she was watching him during this time, saw that he consumed several shots of whiskey, quite a few, she says. She saw the incident with the fall. She knew Daniels had gone out. She saw him come back, and Hard ordered another beer. She was watching this. She was watching Hard during this time. She was observing him, and she said that there was not a point at which she discerned any visible signs of intoxication. She said she couldn't tell whether he was drunk or not.
But then don't we have to deal with the Ashlock case, which the woman in that case didn't exhibit any outward signs of intoxication prior to receiving her last drink, and then the court was looking at behavior that occurred with a half an hour after that point, which in our case we have the individual swinging and a miss and falling on it.